Ready?
Yes. Okay. Defendant's present. Counsel's present. Are both the state and the defense ready to proceed?
Well, Your Honor, we did a deposition last night. We were provided a lot of records that we never did this before, even though I believe I filed pretrial motions asking for all records associated with penalty phase. We were provided access to medical records from the Hillsborough County Jail, I think medical records, medication records, employment records, education records that were never provided to us before. Now, we've given those to Dr. Lazaro, and hopefully we'll be providing those to Dr. Holder, our rebuttal witnesses. But, I mean, we're ready. We can proceed, but this really puts the state at an unfair advantage.
Why were those provided at the last minute?
Judge, I know they were provided yesterday.
I know, which would be the last minute. So why did that happen yesterday?
Judge, I'm not sure. I assumed everything had been provided, but apparently there were some items that were not provided.
Sounds like there were a lot of items that were not provided. Kindly. Okay, is there anything else the state's not been given?
Not to my knowledge, Your Honor.
Okay, we'll state if it creates an issue for you as far as preparation for your rebuttal or cross-examination of the witnesses, you need to let me know. But at this point, we're going to go ahead and see where we are.
Well, what I would ask is who's the defense attorney call this morning? I think we're going to conduct a deposition at lunch. Is it Dr. Wu we're doing? Is that right?
Correct. Judge, the plan is slightly changed because the video was going to be shown first, but it's still being edited. And I have a scheduling issue with one witness, so I'm calling Aubrey Land, the prison official. I'm calling Dr. Eisenstein, and then I've told Dr. Wu to be here close to lunchtime so that way we can depose him and he would testify this afternoon if we still have time.
Mr. Land, or Dr. Land, was provided to us, I believe, when the Monday jury selection started.
Right.
We have not had an opportunity to speak with him or depose him. We deposed Dr. Eisenstein last night out of priority, I guess, over anything else, and they're until almost 8:30. So if I could just have an opportunity, even if it's a 15-minute break in the proceedings, so I can go out and talk to this doctor before he's called the prison expert.
He's not a doctor. He's a former law enforcement and corrections officer that is going to testify about prison life and things of that nature.
Okay. And so who is it that you would be, of the defense witnesses, who could they call that you would be ready to cross-examine?
Eisenstein.
Eisenstein.
He's the one we got all the records from, but I believe we can proceed with cross.
Okay. So,
And that's fine, Judge. Mr. Land indicated to me, I had him to ask him to be here this morning because he indicated that he had a scheduling problem, but I'll try to work around it.
okay, yeah, he needs to work around it. We all have scheduling problems, okay? So what we can probably do is take an earlier than normal lunch break and give you time to, you have to depose Dr. Wu and then speak to Mr. Land?
Land.
Okay.
Yes, Your Honor.
All right.
There's another issue as far as Dr. Lazaro is here and would like to observe at least Dr. Eisenstein's testimony. I'd ask that she also be allowed to observe the prison official's testimony.
I would object to it.
What's the legal basis for your objection?
Judge, my belief is that a witness invoking the rule basically that the state witness should not be able to listen to all the testimony that the defense is presenting.
Isn't there an exception for experts?
There is, Your Honor.
I don't know how Mr. Land qualifies as an expert
Yeah, no, I'm saying,
Dr. Lazaro would rebut.
well, I'm going to overrule the objection. She can sit in and watch those too.
Thank you, Your Honor.
Okay? Are we otherwise ready to proceed?
Yes, Your Honor.
Okay, very good. And for the record, the defendant is present and all of our jurors are here.
They are.
So let's go ahead and bring them in.
All rise, jury entering.
Very good. Everyone have a seat. Welcome back, everyone. Last night, anybody watch, read, listen to any news accounts related to this case, do any independent research, or speak with anyone about this case? No. Okay, very good. Members of the jury, you have found the defendant guilty of one count of murder in the first degree. The punishment for this crime is either life imprisonment without the possibility of parole or death. The attorneys will now have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say, however, during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence that you heard during the guilt phase of the trial, is presented in order for you to determine, as you will be instructed, number one, whether each aggravating factor is proven beyond a reasonable doubt, and two, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty. 3, whether mitigating circumstances are proven by the greater weight of the evidence. 4, whether the aggravating factors outweigh the mitigating circumstances. And 5, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is a standard to guide the jury in making the choice between a verdict of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction it is one which is not stable but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to the mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose death, do not move on to consider the mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors that you unanimously find to have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as the sentence to be imposed.